Do you believe in second chances? In this courtroom, the judge is faced with a defendant, Mr. Rivas, who has repeatedly violated an illegal trial order. Will Rivas's explanations and shifting outcomes be enough to sway the judge's decision? Follow the tense forum where faith and truth collide, and a second chance can be all or nothing.
Mr. Rivas also has a felony. That case was dismissed today, so we just have our misdemeanors now.
What am I supposed to do, Mr. Rivas? Over and over and over. I ordered you not to use any illegal substances, and yet it continues to happen. No, I mean, what? Felicia, when was the first test that we did on Mr. Rivas?
My last test was the test I told.
Did you represent him on the aggravated assault?
No, I didn't, Judge. He was just appointed an attorney this morning up there, and the case was dismissed the same day that he was appointed an attorney. Who was the attorney appointed?
Mr. Andrew Williams.
Andrew Williams. But I'm sure you know what he's going to say. He said he was trying to explain to you that the marijuana was in his system from when he was arrested on January 22nd.
Yeah.
Judge, the only test we have is from the 18th.
What day? You mean today?
No, the 18th, February 18th.
Okay, that's,
I just did a test last week. That was my
And
first
that's what
test.
the,
you've been on bond in this case since September. Since September, you've known not to use any illegal substances. It's now February. What possible excuse could there be?
There is no excuse, Judge, given that.
He has 3 open cases with us. I mean, I've continually told you not to use.
I think one of those cases was possession of marijuana. He said that's the date that he used, the day that he was arrested for possession of marijuana.
September 28th.
Yeah.
Sorry. Goes with you. I don't know what to tell you, Mr. Rivas. You're not getting it. I'm telling you no using.
Can you give me another test? My first test. I did this Friday. I have a ask for UTI, which I paid $200 for. I can show you proof. I have an email of UTI. I've been changed. I've been trying to change. I told the door upstairs too. I haven't smoked since I got out. I'm an ankle monitor. I haven't smoked since I got put in this ankle monitor, Judge. You can.
When you get that ankle monitor?
The day I got released from jail.
after he checked in for the drug test on the 18th, he did state to us that it.
You got the ankle monitor on the 18th? So you tell me you stopped smoking 2 days ago?
No.
Sorry, that's what he told us. He had consumed marijuana in about 2 to 3 weeks from the 18th.
So 2 to 3 weeks ago, you're telling me he says he stopped?
No, I stopped since I got out of jail.
January 22nd, Judge.
That's the day I stopped.
That's what he
I enrolled in college now, which I paid $200.
That was the last arrest because these cases were
If
different.
it's January 22nd, it's 1, 2, 3, 4 weeks and 3 days, 4 days.
I know I can change, Judge. I've been trying to better myself since I got put in this ankle monitor. I've been in jail. I don't want to be.
Yes, it's from January 27th or January 28th.
January what day exactly?
They entered it on the 28th, but I don't believe he got it until sorry, they entered it on the 27th. I don't believe he got it.
What was the absolute last day?
The day I got arrested for the aggravated for this charge, this case that I got dismissed, I was parked in the car. That's when they had it. That's the last time I smoked.
December 19th, I see as the date of arrest. Or are you telling me the time you stopped was the time they put the ankle monitor on you?
So
Tell me, Mr. Clay.
the December 19th is when that felony was filed. He wasn't arrested on that felony until January 22nd. And he's
Okay.
saying that's the last time he smoked. When he got out on bond for that case was January 27th. He was given an ankle monitor as part of the
Yes, he was
felony
given an
release.
ankle monitor in the jail on the 27th.
And I haven't smoked ever since. I'm trying to change.
All right, then I'm going to give you the benefit of the doubt. Then I'm going to calculate it from the 27th and on to give you the benefit of the doubt. I will test you again 40 days from that day, 45 days. If I find that you test positive again for marijuana, it's not going to go well for you.
Yes, sir.
If you're lying to me, it's not going to go well.
I lied.
Do you understand?
Yes, sir.
Do not use. Do not hang around with using, because I don't give a rat's behind if you tell me you're in a car and everybody else is hotboxing it. I don't care. Do you understand?
Yes, sir.
If you're really working this hard, to better your life, which is really commendable, right?
I just got a job. I just enrolled into UTI, which I had proof my Gmail, which is this Friday. I have a touring class, and then I have in tour in the.
Then don't muck it up by hanging with the wrong people. I bet all the cases that you have now. You speak Spanish?
Yes, sir.
Dime con quién andas, yo te digo quién eres. Do you understand?
Yes, sir.
All right, Felicia, we know what it is. Okay? All right, Mr. Glenn, make me proud. I'm not asking for much. Don't
trying to change
use, but don't put yourself into a position when you're hanging around with bad folk.
Yes, sir.
All right?
Thank you.
Have you ever handled a case where the judge had to issue an ultimatum to another judge? This case is a prime example. A man out on bail for robbery gets arrested again, this time for a theft at Walmart. Will the judge fight to give him another chance? Stay tuned for the full hearing, where the shadows of the law clash with the weight of justice.
You were on bond for theft,
Yes, sir.
and now you've picked up another. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, will be appointed to you, sir.
Yes, sir.
On February 17th, 2025, an officer was sitting in a Walmart parking lot and observed a male wearing a black jacket, red shirt, and brown pants running at a full sprint from the front of the store with what appeared to be a large box holding near his waist and trying to conceal with a jacket. The officer shouted to the male to stop running approximately 60 feet away. The defendant stopped, made eye contact with the officer, and entered the passenger side of a motor vehicle. The officer shouted for both occupants to stop, at which time the motor vehicle sped off, exiting the parking lot. The officer was advised by another officer that he was behind the motor vehicle at a Valero gas station parking lot. The defendant was detained and recognized as the same person observed to run away from the store. The complainant, a loss prevention associate, provided video showing the defendant walking past all points of sales with a speaker, total value $289, and the defendant was later ID'd by his Texas driver's license.
He's on bond for a prior assault.
For
Was
a
it-
prior theft, yes. Sir.
Right. Was that at the Walmart? And did we order him not to go to a Walmart?
That prior theft was from a Home Depot, Judge.
I can't continue to give you PR bonds, Mr. Mary.
Yes, sir.
You continue to pick up cases. What am I supposed to?
I don't pick it up.
Stop.
Yes.
I'm not asking you to talk. I'm just telling you, I'm not going to continue to give you PR bonds. You're going to stay with me. You picked up a bond while you're on bond. I told you not to pick up any more cases. You've now picked up another case.
Nobody told me anything. The first time was,
Stop. I'm revoking your bond. I'm putting you in jail now. I'm going to appoint your lawyer and we'll talk and we'll figure out where to go from here. But this is the third PR bond now. No, sir.
isn't that three?
It's 3.
But it's not me though. I only have
This
two.
is not a negotiation right now.
Two.
I will appoint your lawyer. I want you to talk to someone and then we'll figure out where we're going from here.
And
We're approaching with Mr. John Mayer. It should be before the bench.
Oh, on both.
Yes, sir.
Did you just get appointed today?
I did.
Did you want time to look to see about any discovery or anything?
Well, I've spoken with Mr. Mayer, and I've gone through the offense report, at least what's him in the Dems. One of the theft cases is for $103. The other one is like $289. And, he is under the impression that, that taking a plea on this case would be more beneficial for him because he can't afford to pay 2 $5,000 bonds.
Mr. Mary, all I want are my streets to be safe. That's all I want. We gave you a PR bond on your first case. You took off. You didn't come back. We gave you another PR bond. And this time, on the new PR bond, you picked up another case.
that's true.
The point I'm trying to make is
Okay.
I don't ask people to plead guilty just to get out. That's not what I want.
Yes, sir.
What I want is no more issues. That's what I want. So I don't want him to plead guilty just to get out. And I feel that that's happening here. So if I give you a third chance, how do I know you're not going to pick up yet another case? Mr. Mary, we have resources here. All you have to do is ask. If you want food, if you want clothes, if you want something to, eat, if you need a place to sleep, if you want a job, we have resources for you. All you have to do is ask. But this is a problem because
Yeah, I know.
with this right here, pick up another one, you're now looking at a felony charge.
Your Honor, may I? On that first case, it looks as if those were work tools that he was appropriating. On the second.
Let's not, look, I don't want you to plead guilty just to get out. That's not the way that, but I'm going to tell you now that I don't like to play games. If I give you another PR bond, and look me now, because if I find that you pick up another case or you don't show up to court, we will have issues. And I'm telling you, I will not do it. This just to plead guilty to get out. It's not going to happen. Do you understand?
Yes, sir.
I will give you another chance. I don't want you to go to any more Home Depots. I don't want you to go to any more, it was what, Walmart, right? No Walmart. Do you understand? Any of them. No Home Depots. And I will have you speak to counsel now so that whatever you need, we can try to get for you. Do you understand? But this is not a good way to it's setting you up to fail. And that's not what we do. Do you understand, Mr. Mary? Okay. I'm going to grant you a PR bond on both cases. But we need to find out where we're going to go next because I don't want any more issues. You must appear in court every single time, and I want you to stay in contact with counsel. He's going to give you his cell or a number to him. There's no excuse why you can't get in touch with him. Do you understand?
Yes, sir.
Really, I'm not asking much. Just don't pick up any new cases and stay in contact with counsel. That's all I'm asking you to do. Do you understand?
Yes, sir.
This is not the right way. All right. So if you don't mind speaking to him real quick to see what we can work out for any kind of resources you may need.
Yes, sir. Thank you.
Do you believe in second-degree convictions? In this case, a man was facing jail time after being arrested for his first DWI with a blood alcohol level well above the legal limit, but surprisingly, he was also charged with a more serious felony, injury to a child, from an incident that happened before the DWI. Can the judge look past these critical flaws and offer him another chance? Stay tuned for a tense trial, where every string of justice hangs in the balance between mercy and accountability.
First things first, though, is I have Mr. White that's been representing him.
Right.
And I guess, did I grant your motion withdrawal or we're having a hearing now? All right, so come on up.
So Will reached out to me on Wednesday. I spoke with Michael on Friday. I spoke with Michael on Wednesday. And so basically the understanding is that Will's gonna sub in and take over and I guess possibly resolve it.
I'm hired onto this new felony
Okay.
case that triggered this whole deal. I've agreed to sub in on this case to work out whatever's going on here, and I've been talking to Michael about that. The felony case is bogus for a lot of reasons, but talk to the state about this as well.
Well, hold on.
Okay.
Putting the cart ahead of the horse. You went out.
Yes,
Okay.
sir.
You're out.
Okay. And I'm in.
Well, I don't know.
Okay.
You want me to appoint him a lawyer or do you want to?
I'm taking it pro bono because I'm hired on the felony and we want to just resolve this DWI deal today, probably.
Well, because here's the deal. I'm putting him in jail. You picked up a felony while you're on bond for a DWI. You're not supposed to pick up any new cases. You've now picked up a felony. An injury to a child, and it's just now coming to my attention, even though this thing's from November. I'm revoking your bond. Goes with you. Let's talk.
May I be excused, Your Honor?
Please.
Thank you.
Thank you, Mr. White. You did file a motion to withdraw, correct? Mr. White?
He didn't file it.
Aaron,
I thought he
did
did.
you file a motion to withdraw?
Yes, I filed it last week.
I saw it.
I don't have
It's on Douglas.
I just see an appointment form from January.
I see the motion to withdraw. It's there. Do you see it, Seth? Do you need a cause number?
Yes.
I have the 2500939. Oh, no. Okay.
Yeah, can you put it in the queue so I can sign it? All right, tell me.
I know.
There's a certain standard.
I
You pick
understand.
up an injury to a child. I don't know anything about the case. All I know, he's picked up a third-degree felony, and it's a serious charge. It's not like it's a
But, yeah.
trespass, but it's so.
But you know that these charges can be empty.
Well, but I don't know that for sure. All I know is that he's picked up a felony. He's not done squat while he's on bond for this thing. He's literally been riding free, not doing anything for the last 4 months, 4.5 months. Nothing. He's not tested. He's not had, he's literally done nothing. So anyways.
State's offered a time served. I talked to Michael about, hey, my plan coming in was to try to get him back on PTI because
they're like,
the felony is so ridiculous, it blows my mind. But regardless, I was talking about that this morning. He's like, honestly, Will, he's like, the PTI it's not feasible for me to do. He's like, is there any other alternative?
if you want time, take it maybe a day.
I don't need the time. He wants to time serve it today, Judge.
Well, if that's what he wants to do, then that's on him.
Okay. Would the court accept that?
Yeah,
Okay.
absolutely. Look, far be it from me to, because that's what we would do in every case.
Right.
Any case that comes back here, and obviously, state, you need to also be happy as well, right?
Yes, Your Honor.
But it's on you guys, so I'm on board if they're on board.
Okay. I will run it by him just to make sure and then we'll get paperwork started. Thank you, Judge.
Mr. Douglas, you're charged with driving while intoxicated. First offense, it's elevated to a Class A misdemeanor because of the high blow. You are facing up to a year in jail and or a $4,000 fine. It doesn't make me happy to put people in jail, but if you're a danger to my community, I only have one place for you. Do you understand?
Yes, sir.
You need to understand something very serious now, that this DWI is going to go on your record. It'll be there for the rest of your life. It's even there after you die. You get pulled over again, first thing an officer does, they're going to look at your record. When they see this and they look at the other, what do you think they're going to do? Think they're going to be happy? Think they're going to give you a hard time? Probably. So if you even have the most faintest remote smell of anything funky, it's probably not going to go well for you. You need to understand that from now on, it's a minimum of 90 days in jail. Do you understand? You give up a lot of rights by entering this agreement. You give up the right to a trial, right to compel witnesses to testify on behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. Once you accept this agreement, it will go on your record. You can never take it off. Do you understand? You still want to do this? How do you plead to the offense of driving while intoxicated? Guilty or not?
Guilty.
Is it true or untrue that you had a .15 or above? So true to the enhancement. You need to understand one more thing, Mr. Douglas, is that we all make mistakes, right? Everyone's human. But when you continue to endanger other people's lives, there are no more mistakes, they're actions. And when you keep making boneheaded actions, we have longer sentences, bigger jails, more fines. This carries a fine of $4,500. And if you don't do it, you sit in jail 1 day for every $100 you owe. So you can imagine how much jail time you will do on a $4,500 sentence. On a second DWI, it's a $6,000 surcharge. Get a clue. If you want to get lit, great. Take an Uber. $40 anywhere you want to go in this city. You understand? What do you do for a living?
I work at a warehouse.
How much money do you make a month?
I'm sorry. 16.
Look, I'm going to waive your fee for you today. You come back with another DWI, get ready, because it's just, do you understand? Get a clue. Good luck. Oh, I am suspending your license for 180 days, sir. Do not drive until you get a license. All right, sir. Good luck.
Thank you, Judge.
Thanks.
Emotionally weighted, a pregnant young woman faces charges after a violent assault on her boyfriend, who is also the father of her unborn child. What's even more shocking? This isn't her first encounter with the law for similar behavior. Now the judge must decide, protect the integrity of the law, or consider the future of a family about to welcome a new life. This hearing will expose the hidden corners of a turbulent relationship and lead to a ruling that could change many lives. Stay tuned for a courtroom journey filled with tension, emotion, and unexpected turns.
Judge, quickly for Peyton, we did put conditions on him previously, and the GPS curfew that you ordered initially, it was supposed to be obtained prior to the use of 7 to 7.
Yes, Judge. No,
Would you
just do 9.
Okay.
9 to 6.
Yes, Judge.
Monitor, he doesn't have them?
He should. Mr. King, you have a GPS knowledge?
You just pulled it out. We said prior to release.
That was supposed to be, oh, sorry, he was out on bond, and I think the charges got filed, so he was taken in, they must have cut it off.
You're Ms. Jimenez Alvarado.
Yes, yes.
Ma'am, you were charged with assault of a family member. You were facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, will be appointed to you, ma'am.
Yes, yes.
On July 2nd, 2024, officers were dispatched to FSRA at the intersection of Cherry Brook and Cherry. The complainant witness stated during a verbal argument, the defendant struck the complainant witness on his face once with a closed fist, causing pain. The complainant witness then grabbed the defendant in a bear hug before releasing her and went outside to separate himself from her. The defendant followed him outside and struck the complaining witness with a stick about his face and neck several times, causing pain and visible injuries. The complainant witness stated the defendant got into the vehicle and began driving up and down the street, honking the horn at him. And the complainant witness stated that while walking, the defendant turned the vehicle into a driveway and the vehicle came extremely close to him. I'm not sure, but I mean, that's the other allegation, but I think the AFM stems from the stick and the punch.
What is the relation between the two?
They're common law married, Your Honor.
For what?
They're common law married.
Prior aggravated assault of a family member, is it the same complainant?
It is not. It is not, Your Honor. And the case has been it was dismissed.
I know, but I'm curious to see if it's the same
It
complainant.
is. Yeah, it is.
Oh, I'm sorry. It is my fault.
Yeah.
I don't want you to have contact with this person.
Okay, well,
No, she's a prior aggravated assault that was dismissed not months ago. And now we're charged with another assault?
Your Honor, it was 9 months ago when the case was dismissed. This case is from July 2nd of 2024. So this case is 8 months old. They were still together. They've been together. As you can see, she's pregnant. He is the father.
Great, so we have more stress now, you know?
There is a note that says an officer, Dennis Rice, tried to perform an on-scene evidence-based risk assessment to talk to the CW and to risk of lethal assault, and the victim refused. So and the reason why she knew about this, Judge, is she was in the process of renewing her DACA, and they told her that she may have an open warrant. So she went and checked, and then she hired us. So this case was, filed a while ago, Judge.
What happened in the aggravated assault, please?
What I have here, Judge, is that complainant witness and defendant were in a dating relationship. Defendant came to the complainant witness's work and pointed a gun at him while he was walking out, while she was in her vehicle. While he was on the sidewalk, the defendant fired the gun at him from inside the car.
She shot a gun at it, allegedly? Is that what you're saying? I don't want you to have contact with this person. I don't care. I'm entering now what's called a magistrate's order for emergency protection. This is a court order that identifies this person as a protected individual. Mr. Chicas as a protected individual. You cannot commit family violence or assault against this person. Commit an act.
Don't say anything. Don't say anything.
I want you to listen, because if you violate this court order, the state can and probably will file a violation of protective order against you, and that is the capital murder of misdemeanor. Do you understand? You are not to have any contact with this person. You are not to threaten, harass, use another person to communicate a threat or harassing behavior. He is now listed as a protected individual. You cannot commit an offense in furtherance of section 42.072 of the Texas Penal Code, which is the stalking statute. You cannot be in possession of a gun or go within 200 feet of where he lives or where he works. Do you understand? If you violate this, like I said, the state can and probably will file an additional case against you. And then I, on this case, will revoke your bond. Do you understand?
Yes, sir.
I will give you a PR bond now, but it's the only one that you're going to get. If I find that you're a danger to my city, I have only one place. Do you understand?
Yes, sir.
Just so you know, Your Honor, the CW has a criminal history as well. In fact, I think he was on parole.
Doesn't make me feel better.
Okay, it's,
Two people just,
I understand.
there are people who are good for each other, and there are people who aren't so much. When you have cancer, what do? You cut it out, because if you don't, it kills you. There are certain people in life that may be like that as well. Now, a second case. I don't want anything to happen. And so the best prescription is no contact. You're not to be in possession of weapons as well. You're not to consume alcohol or illegal drugs. Do you understand?
Yes, Judge.
252-5470.
And so, Judge, obviously they.
I'm not, Marcos, it's not absolute, right? I'm not talking forever,
Okay.
but for now, I don't want any contact. Everything is coming to head now, and the last thing I need is something else to happen, more drama, and I just don't want any more dead bodies on the road. That's all.
I understand.
So because you have a lawyer, I will waive your appearance, but it is your responsibility to stay in touch with Mr. Adrogi, and he will tell you if and when you have to come back to court. If he tells me he cannot get a hold of you, then I will issue a warrant for your arrest. If you pick up a new case, I will issue a warrant for your arrest. All I'm asking you to do is just behave yourself, don't have any contact, and don't use alcohol or illegal drugs. For now, I'm going to have you sign. Oh, wait a second. I need a bond, right? There's no bond that's set? Okay. I'll set your bond at $3,500 and I will grant you a PR bond. You will have to sign a receipt of Victoria. You will get with Felicia for your bond conditions, and after that, you'll be free to go.
Yes, Judge.
Thank you, Judge. Maybe excuse me.
You can sign them all right now. Mark, Marcos, you can sign them all right now.
A 22-year-old man with a long criminal history, including fleeing from the law and a robbery in another state, now pleads with the judge to grant him bail to appear in Colorado. But with a prior ruling denying bail, will his family's estate still be transferred as promised? This hearing becomes a battleground between second chances and accountability, between leniency and the fear for public safety. Has this young man earned redemption, or will his past finally catch up with him and seal his fate? Tune in for a dramatic, intense, and surprisingly quiet trial.
Judge, I wanted to approach on a fugitive case. I wanted to see if we could bring him out.
What would you like to do?
Judge, I wanted to approach to see if you would reconsider a fugitive bond.
Okay.
Yeah.
Good morning, Mr. Jackson. So, Amy, we spoke about this last week.
Yes, Judge.
I denied him a bond last week.
Yes.
Has anything changed?
No, Judge, it's still asking for no bond.
Tell me, I don't even remember. What does he want it for?
He's wanted from Broomfield County, Colorado for failure to appear for burglary. It was issued in October of 2023. He's also here in Harris County for evading other vehicles. He also has other criminal history that we can go into, but it would need to be offline stream.
I remember that. Okay.
Judge, yes, first criminal history. I don't know how much we should go into that. We are
Don't
here.
go into anything that's,
No, just,
We're going to-
it's not something I want to go into anyways. I don't think it's relevant to whether or not he's gonna turn himself into Colorado or not. I think if we focus on that, the argument is that he would like an opportunity to go turn himself into Colorado for this pending case. He hasn't been found guilty out there. He's presumed innocent. He would like the opportunity to go turn himself in. He hasn't messed up in your court before. He hasn't been given that opportunity before. And he is not asking for a PR bond. He's asking for a bond sufficient enough to guarantee that he will go turn himself in over there. He has family members here in court today showing their support for him. He's got 3 family members. After talking with them, they are inclined to help him make a bond as well. They understand the risks. He understands the risks if he doesn't turn himself in over there. He understands the complications of having to meet his court date deadlines. And so we are just asking for you to consider giving him a sufficient bond to go turn himself in.
who's here? Mom?
Judge, we have his sister, we have please. We have his sister-in-law, his girlfriend, and his cousin. His sister-in-law and girlfriend.
Thank you for coming, God. Really, I appreciate you coming. You're welcome to come up if you want.
And these are the family members that would be responsible for helping him post a bond. They would be posting the bond for him, and they understand the risks involved.
Sure.
Hi.
Thank you for coming. Thank you for coming. Thank you for coming. And I told this to Mr. Jackson about a week and a half ago. There are several things that I look at when I give someone a bond. One of the things I look at is their prior criminal history, what they have done, how old they are, and whether they've left a wake of just destruction in their path. Mr. Jackson is very young. He's what, 20, 22? And in the short time that he's been alive, he's managed to rack up a ton of cases. Just here in Harris County, an evading that was dismissed in 2021. He picked up a felony theft in 24, an evading arrest in 24. He has a fugitive case out of another jurisdiction of another state. And now he picked up here 2 weeks ago, another evading arrest. So the common theme that we have here is I'm going to take off and I'm going to try to evade. That's the common theme that we have. And the two things that I don't want are, number one, I don't want him to pick up another case. And most importantly, I don't want my public to be in danger. These are the things that I consider. What is he wanted for out of state?
Failure to appear for burglary.
And now he has another burglary in another state for failure to appear for that. At what point do we say when? So my point is that the problem is that if I give him a bond and he just takes off, all you guys are going to lose out on all that money. And what happens if he picks up another charge? So these are the things that I consider. And this is why I denied him a bond the first time, is because what the common theme that we have here is that in the short time that he's been an adult, there's a ton of evading and flight cases. That's why I didn't want to give him a bond. Because in my opinion, he already has 3 flight cases. Do we need a 4th? And that's what scares me. Carter.
Judge, considering all that, considering his family's here, we would be asking for an amount that ensures his attendance in Colorado. I think by putting an amount on his case, it would ensure that he hasn't had this opportunity before. He hasn't had a risk of losing money before. This risk would ensure that he does what's right and turns himself in over there.
But he has, though. You know, he got out in Colorado, failed to appear on that. He's constantly trying to evade here as well. It's a constant thing. And I can't continue to say, okay, it's okay for you to do this. Look, it's not okay. The bill comes due. Do you understand? At 22, you have all these cases. Life is hard enough as a young black man in today's society as it is. And now with all this, really? You want a pat on the back for all this? You want me to just, no. Now the bill comes due.
Judge, if I may, respectfully, one of the things that I wanted to do was look into the Colorado system to see if it was actually a failure to appear or if this was a sort of like a to-be warrant here in Texas. I wasn't able to log into that system over there, and I don't think we can make the distinction on whether or not it was a to-be warrant based on the documents that have been filed, or if this is one of those situations where he missed a court date.
Regardless,
Okay.
all we have are someone constantly trying to evade capture. They're trying to evade police one way or the other. I have a feeling if I let him out, the same thing's going to happen. And I don't want that to happen. I don't want you to pick up a 4th case, 5th case. I certainly don't want anyone to be injured. And that's it. At 22, all this baggage, it's not going to happen, man. The bill comes due. I certainly appreciate you guys coming. I know that you've taken a lot out to be here today. It's just too much baggage. I'm sorry. Thanks, guys.
Thank you, Judge.
All right, of course.